part of the question as framed relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are 4 stages in the amendment process under the popular initiative routes. The initiation stage, that is the correction of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IEBC like it did the 2 popular initiatives dubbed Okoa Kenya and Punguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IEBC, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I am of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, a timeline of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IEBC, have an obligation to facilitate a broad participatory process that includes this stage for public participation. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, Tuyot J.A. arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Dennis Wawero, co-chairperson of the BBI National Secretariat. In his affidavit sworn on 5th February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. It reports that BBI Task Force Steering Committee and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed with affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgment. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Waweru, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the steering committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting laws to actualize constitutional imperatives. In the end, I hold that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court by petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with Sishar and JEN dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandate, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, "Each commission shall consist of at least 3, but not more than 9 members." Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of Parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5(1) appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in registration cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of this court in the case of Hassan Joho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Katembo, J.A. and a qualifier subject to the nature of the proposed amendments. Musinga J.A. disagreed with the learned judges of the High Court and held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On its part, Tuyot J.A. held that since IEBC had not received the requisites and had not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. That prevents parties from approaching a court before a party has been subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was yet to be subjected to the county assemblies for debate. This means that IEBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IEBC obligation under Article 257(10) of the Constitution and not a reason to yacht JEA was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277(10) of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are: number one, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10(2)(a) and 89(7)(a) of the Constitution. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining the amendment bill. In addition, there was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake the verification of signatures in support of the amendment bill under Article 257(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on costs, this being a public interest matter, I find each party should bear their own costs of this litigation and also the other courts below. That is my judgment. I will now request the Honorable Justice Ouko to read his judgment.
Thank you, Judge President. This is a summarized version of my judgment. This appeal, consolidating 2 others, marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 257 of the Constitution. The road traveled by Kenyans since 1991 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, mass actions, and even loss of life. Like the biblical narrow road which leadeth unto life, it was the way, the only way to a new beginning. And so a road characterized by violent demonstrations, protests, mass actions, and even loss of life. Of his pen, President Mike, like the biblical narrow road which leadeth unto life of a new era. It was the way, before the only way to a new beginning. People, and so a road cannons broke into a 21-gun salute. The president released 2 white doves as a sign of peace, love, hope, marking the birth of the Second Republic. Having emerged from this phase, Kenya embarked on building constitutionalism, giving meaning to the terms and values of the supreme law to which Kenyans must turn to for protection in times of need. It was time for the people to read meaning into its words. It's only through this robust enforcement, application, and interpretation by courageous citizens, lawyers, legislature, executive, and even more so by judges, that the Constitution will be safeguarded to realize the Kenyan dream contained in the preamble. And so, with the difficult history of constitutional making enumerated in the lead judgment of the Honorable Chief Justice, the question I pose: have the Kenyan people stayed true to the promise in the preamble that we, the people of Kenya, adopt, enact, and give this Constitution to ourselves and to our future generations? So there were 7 issues that were framed, the first one being that on basic structure doctrine, and that's the one I now turn to. In the last 50 years, since the Supreme Court of India decided Kesavananda case, the name Kesavananda has been synonymous with the basic structure doctrine, and although the term basic structure has not been used, has been used in a few cases in this country in the past, it is during the hearing of this case from the High Court through to this court that it became a household name. I suppose, knowing Kenyans in our true unique sense, there may be children today who are called basic structure, perhaps basic structure George Ochola. Just as there may be also in India children born in the 1970s who are given the name Kesavananda after the Hindu spiritual leader who lent his name to the iconic case as the petitioner. Unfortunately, I believe you are all aware, Mr. Kesavananda passed on the 6th September 2020 at the age of 79 years. The origin of basic structure doctrine has largely been attributed to the Indian Supreme Court decision in Kesavananda, with very little or no acknowledgement at all of Professor Conrad's contribution. Yet it is this German scholar who exported it to India. Professor Conrad's theory, which was applied in Kesavananda, postulates that there are implied limits on the power of Parliament to amend certain protected provisions of the Constitution, called the basic structure. Under Article 368 of the Constitution of India, it is Parliament and Parliament alone that is reposed of the power to amend the Constitution. And indeed, clauses 4 and 5 even explicitly limits the power of the courts to review any act of Parliament to amend the Constitution. No amendment of the Constitution made by Parliament pursuant to the provisions of the Constitution can be called in question in any court in India on any ground. However, in construing Article 368 and the limitations on the powers of the court to question the power of Parliament, notwithstanding, the Supreme Court in Casavananda held that although the article donates exclusive power to Parliament to amend any provision of the Constitution in accordance with the procedure in that article, the powers could not be used to damage, emasculate, destroy, abrogate, change, or alter the basic structure or the framework of the Constitution. The theory was itself influenced by the Germans' political and constitutional history. Under Article 76 of the Germans' original constitution, called the Weimar Constitution, Parliament had the power to amend the Constitution with the procedural restraints that required 2/3 votes of the members of its parliament to pass an amendment. Adolf Hitler, that well-known but reviled figure in history, used this same procedure, a procedure which is anchored in the Constitution, effortlessly to overhaul the entire Weimar Constitution, and arbitrarily took away rights to freedoms of speech, expression, association, and habeas corpus. He then declared the state of emergency. This experience was to inform Germans' constitutional reforms. In their new constitution, the Grand Gazette, the Basic Law, substantive limits have been introduced to the amending power of Parliament. Article 79 of the Basic Law explicitly bars any amendment to the provisions concerning the basic principles like federalism, democracy, rule of law, separation of powers. Our own history is equally replete with the examples and instances that led to agitation for constitutional reforms, as the former constitution was in no better ranking than the Indian or the Weimar constitutions. The former constitution provided for its alteration as opposed to amendment under Section 47 and vested wholly the power to amend it in Parliament, a common denominator with the Indian and the Weimar constitutions. Our Parliament under Section 47, like parliaments of the two nations, could indiscriminately change, and did in fact change, the Constitution at will in any manner whatsoever without reference to the people. The history of agitation to reverse the trend and save the Constitution leading to the promulgation of the 2010 Constitution is well known and are chronicled in detail in my main judgment. But why is this history important? Just like India and Germany, where the seed of basic structure doctrine was planted, it is their unique history that influenced the path of constitutional reforms and the decision of the courts in those jurisdictions in applying the doctrine. Constitutions the world over reflect the uniqueness and specificity of each society, even if lessons or experiences can be drawn from those places. In the Kenyan situation, drawing from the past, informed by the present, and focusing on the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the current inbuilt mechanisms and safeguards, as well as the complex and elaborate procedures in the Constitution itself. The situation the Supreme Court of India was addressing in Kesavananda is unique to India based on the specific provisions of the Indian Constitution, Article 368 to be exact, their experience, and also based on their history generally. Therefore, in relying on Kesavananda, hook, line, and sinker to address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approaches to president because it is inappropriate to pick a president all over the world simply because they appear to provide an answer to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Kesavananda in interpreting Section 47 of the former Constitution in the Njoya case because at the time our constitutional framework was more or less similar to Article 368 of the Indian Constitution in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitutional making process, from the Bomas draft, the Wako draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance to have a Constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the abusive hyper-amendments of yesteryears. This balance was achieved by clear, unambiguous, and distinct tiered or multi-stage design model codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary and popular initiatives have failed essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill 2016, Punguza Mizigo Bill of 2019. To this extent, even the two courts below agree that Article 255(1) embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below and the dilemma flowing from them is the imprecise scope and extent of basic structure doctrine. Which provision in the Constitution of Kenya, for instance, are not amendable through the procedure in Chapter 16? What does it mean, for instance, when the High Court and the Court of Appeal accept, on the one hand, that all articles in the Constitution are amendable in accordance with the constitutional procedures provided, but on the other, qualifies the statement by declaring that basic structure of that very Constitution cannot be altered using the amendment power in the Constitution? What does it mean when they declare that the basic structure consists of the preamble, the 18 chapters, the 16 schedules? Is it the Constitution is in entirety as a basic structure? Where do Kenyans who wish to propose amendments to the Constitution go to be shown which provisions cannot be amended using Chapter 16 procedure? Do they go to some deity, some oracle of Delphi, for instance? In interpreting the Constitution, courts must provide pragmatic solutions without adding confusion to the controversy that the parties have brought to them for resolution in the first place. Amending the Constitution is not a light matter, therefore, limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavananda case, every court has attempted to identify by listing some of the essential structural elements of the Constitution that in their individual perceptions constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That is in answer to the question of where is the juridical basis in the Kenyan context for the proposition by the two courts that the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and collision of views, constituent assembly, debate, and ultimately a referendum. The last matter under this ground is to consider the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill amounted to dismemberment of the Constitution. Besides the number of articles sought to be amended, the courts were concerned about their overall effect, that they were so far-reaching in character, scope, and content as to, and I quote, shake the foundation and alter the identity and character of the Constitution as to effectively dismember it. The learned judges variously defined the word dismemberment to mean doing any of the following in the Constitution: unmaking, replacing, disassemble, completely change identity, abolish, tear apart, amputate, and rough mutilation.